I want to issue a very warm welcome to all the folks in attendance for this community conversation on pretrial. My name is Carlo Esqueda. I am the elected clerk of circuit court for Dane County, coming to you right now from the Dane County Courthouse. I'm also currently the chair of the Community Justice Council for Dane County. I'm going to turn things over to our very able facilitator, Colleen Clark-Bernhardt, who will see to introductions and get the agenda rolling.
Thanks so much, Chair Esqueda. And Lauren, if you can just kind of scroll in the background the protocol for this evening, that would be great. So this evening, we invite you in Wisconsin to bundle up and listen in. For those who aren't in Madison or Dane County or Greater Wisconsin, it's very cold out right now. So it's a perfect evening to listen in and have an opportunity to meet and ask questions of some national experts on bail and pretrial, as well as local experts here in Dane County. Now, we have a lot of people online today, and so during the event, we will have some content. So setting the stage, what's happening throughout the country, what's happening more locally, and finally, what's the judicial perspective. At the end of that, after about a half hour, a little bit more than a half hour, you'll have an opportunity to ask questions. Please use the chat box. We'll see your name, but say, I have a question regarding, and then you can enter your question. We will then popcorn, which simply means I'll be selecting people with different questions, different areas to select and pull up. You'll be then promoted to panelists. If your question is not answered, we will, within 10 days, be answering all those questions in written format, and we will then send those to all registrants. They'll also be available, as well as the link to this recording on the CJC website at cjc.countyofdane.com. With that, we will start kicking it off with our national technical assistance provider. We're really very lucky and pleased to host today Advancing Pretrial Policy and Research. We have Dr. Calvin Banks and Arlene Rojas. They will introduce themselves, but I must say Dane County is one of the lucky counties in the country because we get to partner with excellent folks all around the country who help inform us, help build policy and practices around Dane County culture. So with that, I will kick it off to Dr. Banks and Arlene Rojas. Thank you for coming.
Thank you so much, Colleen, and good evening, everyone. And Lauren, thank you for going ahead and sharing the slides. By way of introduction, my name is Kelvin Banks. I'm a senior manager at the Center for Effective Public Policy with primary responsibility on the APPR initiative, Advancing Pretrial Policy, as well as research. I've been with the center for about 2 years now. Immediately preceding my time in this space, I was the director of pretrial services in Harris County, Texas, for about 4.5 years. Prior to that, director of pretrial services for 3rd Judicial Circuit Court of Michigan for 3.5 years, and a probation officer for about 17 years in 4 different counties in the state of Michigan. So I bring to this conversation through the lens of a practitioner at all levels, from C-suite executive all the way to first line staff. Concurrently, I'm also a therapist. And so throughout this conversation today, you'll hear some of the behavioral science things that we talk about as well. And with that, I'll turn it over to my colleague, Orleni, to introduce herself as well.
Thank you and good evening. My name is Arlene Rojas. I am a senior manager at the Center for Effective Public Policy. I've been with the center for a little over a year, really focusing on supporting counties and jurisdictions within the different initiatives at the center on their racial equity and community engagement efforts. Prior to that, I worked for over 12 years in New York City at the Center for Core Innovation, was director of court programs. And in that role, for 6 years, I oversaw supervised release in New York City, starting in 2016 when it was a discretionary program, means it wasn't part of the bail law. all the way up to after 2020 when bail reform happened in New York City and supervised release or pretrial release and pretrial supervision became part of the law. And I was focused on supporting 3 of the 5 boroughs, Bronx, Brooklyn, and Staten Island. Prior to that, I worked in many alternative detention programs to safely release people with mental illness and connect them to services and programs in community, as well as alternative to incarceration programming. Again, really focus on low-level offenses, misdemeanor offenders, and diverting them away from jail and into community-based programming and supports, including vocational training, housing, and behavioral health services.
Excellent. Thank you so much, Orleni. And Lauren, if you go to the next slide, and I think there's also going to be space and time for you guys. If you need additional information on our bios, those will be available by way of a hyperlink. As we mentioned, APPR is an acronym for Advancing Pretrial Policy and Research. It is managed by the Center for Effective Public Policy and supported by Arnold Ventures, LLC. This is our website, advancingpretrial.org. There is a ton of information, or if you are looking for additional information about research, legal analysis, various things of that nature related to risk assessment, particularly the public safety assessment, which is adopted in Dane County. There's a ton of information on our website. We welcome you to go to our website at advancingpretrial.org. In addition to our website, we do have an APPR community. So if you want to go on, there's a ton of folks, over 1,000 people that are registered that you may ask questions, anything related to the pretrial world or space. Many of folks will respond. It's a very active community as well. So we welcome you to join our APPR community as well. Now with that, we're going to start with, Orleni and I will cover 3 broad areas. I'll start with the approach. She'll come back and talk about the national landscape, and then I'll just go through a final slide in regards to our process in terms of when we engage localities to support them in their pretrial advancements. So in terms of an approach, APPR approaches pretrial justice through 5 broad lenses, covering the law, data, best practices, as well as research and equity. As it relates to the law, and we'll just talk more federal case law, these are 2 laws that are used foundationally in the pretrial space to kind of give guidance as it relates to how pretrial justice should be carried out within localities. The first one is based on a U.S. versus Solero, which simply says if any conditions are imposed, they must be the least restrictive to provide a reasonable assurance of court appearance as well as public safety. Those are 2 major outcome performance measures as it relates to the pretrial space: court appearance and public safety. Court appearance is based on the Bail Reform Act of 1966, which simply says if a person is released, what is the likelihood they will return to court, as well as Bail Reform Act of 1984, which simply says if a person is released, what is the likelihood they will not commit additional offenses. Again, this is U.S., this is this case law. Secondly, we look at the Stack v. Voyle case, which simply says that each condition or conditions must be imposed and must be individualized. This is a case that had multiple people that were charged on the same offense, and there was the same bond amount set for every single person without understanding their individual risk factors. And so this case gives guidance into making sure that each person that comes before court, that they're assessed on an individual basis based on their circumstances. In terms of data, what we want to kind of focus on in this conversation is really based on the public safety assessment, developmental, as well as validation data. As we mentioned, the PSA was implemented in Dane County. And so based on the PSA validation and developmental data, which was the largest data set for any pretrial release assessment in history, and there was 1.2 million cases that were used, 77% of people within those data sets appeared in court. 69% of folks within that data set were not arrested for new offenses during their pretrial stage, and 80% overall people are successful pretrial. And so we want to say this because this is a mantra we often use, that majority of the people that are released pretrial are overwhelmingly successful. It's not lost on us, and we want to acknowledge that and raise that up within the spaces that folks that fall within those categories or outside of those categories in hyperbolic cases. Sometimes those cases do get a lot of attention, but there are a small amount of cases. You have a small amount of cases that sometimes that cycle through your system, but we encourage you to continue to look at your data and look at the numbers. And what we found is, even though these are national numbers, that oftentimes through validation studies, they also vet out in localities as well. So in terms of best practices, we have several places that we draw our best practices from in the pretrial field. One is based on the National Association of Pretrial Service Agency, their standard on pretrial release, which was revised as recently as 2020. Also, APPR has also created a pretrial roadmap to pretrial advancement that give guidance to localities as well as to what are the best things that you should have in place within your pretrial system. In terms of research, we won't go into research today, but we want to just broadly speak that empirical research, this really helps us understand what helps and what works to achieve court appearance, as well as no new arrests. Again, those two tenets on which pretrial services in the pretrial phase are based on. And then certainly last but not least, as in terms of our approach, equity. And this is simply just saying that, you know, in some spaces, we all understand and agree that equality is important. Where equity focus on, if you look at the picture on the left, the end goal for these three individuals was being able to reach the apple on the tree. And so to the person on the left, this person needed 2 steps to reach the apple on the tree. The person in the middle did not need any assistance, and the person on the far right needed 5 steps to reach. And so it's a matter of giving people individually what they need to achieve the outcome that's desired. So collecting data on race and ethnicity, identify policies and practices that create or exacerbate disparity, as well as community engagement. And Orleany's going to unpack that a little bit more later on. Speaks to people's most impacted in the system, and it speaks to community members impacted in neighborhood as well. So again, equity is our last lens that we're talking about. And with that, we'll turn it over to our colleague, Orleany Rojas.
Thank you, Dr. Banks. And so for us, we want to take a look at what does this look like at the national level? What is the work that we're doing in pretrial justice? And so at the national level, advancing pretrial justice is focused on supporting state and counties or localities and their criminal justice stakeholders and community stakeholders with their pretrial release decision-making process. And why does this matter? Because over 400,000 people are detained pretrial in local jails nationwide right now. And of those, over 50% of people detained are charged with nonviolent offenses. And this is a population that criminal justice and community stakeholders target to identify people that can be safely released. And within this percentage, race and poverty can intersect to create disparities. And so we ask again, why does this matter? Because pretrial detention can negatively impact individuals, families, and communities by affecting jobs, childcare, custody, and it also leaves community-wide problems such as behavioral health, housing, and economic distress unaddressed when we're just simply setting bail and sending people during that pretrial process to jail. It also creates a stressor for, as so many administrators will attest, when you're overcrowding your jails and when you're using a lot of resources, and jail resources are very costly on your county's budgets. And so if we are using a lot of resources in jails to house people that could be safely in community, then we're missing opportunities to again, like I said, look at underlying situations in communities, identified with community, some problem-solving strategies that don't necessarily include or need to be directed to the criminal justice system. Oh, thanks. And so what are legislative and discretionary responses at the national level to kind of go into exactly what I just spoke about? During the past 7 years, we have seen legal changes in many states that limit the use of cash bail and the detention of people pre-trial. A recent example is the state of Illinois, where the legislature eliminated cash bail from their system. But this was challenged earlier this month, and the law has not been implemented. But that was one state that did make the move to eliminate cash. We have also seen the opposite. We see changes that elevate the use of money bail and policies that can increase the likelihood of pretrial detention based on a person's prior criminal history or current charge. And so one example of that is in 2021, the state of Texas passed a law that requires cash bail for people arrested and charged with violent crimes. Additionally, judges must consider a person's criminal history when setting bail. So for example, a person with a past violent crime conviction who's now charged with a misdemeanor or low-level offense may end up with a significant amount of bail. And it is my understanding that your state might be considering some similar changes and things like this. But we're also seeing some states that change their bail laws by restricting the use of cash, begin to consider reimposing restrictions. As an example of that, the state of New York and New Jersey, there are conversations actively about introducing restrictions or rolling back some of the changes that they've made already. And in particular, in New York, we saw that the bail law was changed in 2019, but in 2020, I think a few months after it had been implemented or gone into implementation, there was an amendment to the law that makes specific charges bail eligible again, and gave judges more discretion to mandate conditions of release. And we have also seen discretionary action. That's when the legislature is not involved. And this is counties looking at their jail population and seeing, for example, 90% of people that are held there are held pre-trial or on pre-trial detention. And some have responded by creating jail population review teams that identify people who can safely be released to the community pre-trial with either supports or conditions of release. Next. And so what is the role that pretrial supervision or pretrial programs play? Well, they play a very big role by supporting pretrial justice, monitoring, and supporting people release during the pretrial phase. And so pretrial staff gathers information that judicial officers may consider in setting bail. That could include housing, employment, or behavioral health information for that particular individual so that the judge has that to consider. Or they may complete a risk assessment like they do in Dane County with the PSA that lets the judicial officer know the likelihood of rearrest or failure to appear should the person be released. And so it's really providing additional levels of information that the judges or the judicial officers could consider and find helpful, but ultimately they're the ones that are making the decision on whether to release someone either on recognizance or under pretrial supervision or with some other conditions of release. And once they are, an individual is released to a pretrial program or pretrial supervision, they may be offered voluntary and mandated services, including housing, employment search assistance, or connections to behavioral health services. Staff also reports on compliance and non-compliance with the program and any additional conditions of release that the program is tasked with also monitoring, such as GPS or drug testing requirements, for example. And one, again, crucial fact to consider is that, as my colleague Dr. Bang said, most people succeed on pretrial release, whether it be on recognizance or under pretrial supervision with other conditions of release. Based on national studies, 80% of people released pretrial will return to court and remain arrest-free. And so pretrial detention is connected to community well-being and public safety. It is very much the thought process at the national level that community well-being and public safety go hand in hand. And we're finding that when communities look at their pretrial systems and identify people who can remain in the community under ultimate cognizance, or again, with pretrial supports or conditions of release, it can have a positive impact because pretrial detention impacts socioeconomic factors. Someone, if someone's detained, they can lose their job. That has a ripple effect to their families if they're the main breadwinner and supporter or the main income in that household. But you're also taking someone away from the labor force that could, again, during this time where there is a presumption of innocence, still be able to contribute. But pretrial detention also impacts behavioral health. And so actually detaining someone that, again, could be safely remain in community can have a negative impact on that person's behavioral health, but it can also have a negative impact on that person's risk once they are back in the community. And so again, if other alternatives are used that can support more positive outcomes, then that's where, again, public safety and community well-being go hand in hand. Also, there's other outlying issues that can be addressed effectively in community. And so as I mentioned in the previous slide, when there's a behavioral health issue in a community, when there is an economic issue that's impacting or that's underlying why the person is coming in contact with the criminal justice system, if we're just simply detaining the person and not working collaboratively, then that's an issue that does not get addressed. And if that doesn't get addressed, then it's an issue that continues to bring people into the system as opposed to keep them away from the system. And again, all of it has to do with cost and what's most cost effective. As we mentioned, detaining people does have a high number when it comes to money, and it really allows communities and criminal justice stakeholders and legislators to really think about who do we need to detain, what's the most cost-effective way to do that, and who can continue safely, again, in our communities. And then racial equity and community engagement is really threaded at a national level now. There's a lot of big movement in the last couple of years to really understand the relationship between that and ways in which pretrial release decisions can impact racial disparities, how policies and practices can have an impact on the overrepresentation and disproportional experiences of people based on race and ethnicity, but also other types of marginalized identities. And then when it comes to community engagement, that impacted communities have the knowledge and expertise to improve local pretrial systems by addressing or are being brought to the table to address, again, some underlying conditions and issues that can be dealt with very effectively in community with community organizations and community groups, and not necessarily in the criminal legal system. And that partnering with community can lead to needs and resources that impact the well-being and public safety of people in that county or in that locality.
So as I mentioned, I'll come back and just talk briefly about our process. As Colleen mentioned, we at APPR also feel fortunate to partner with Dane County in terms of improving their pretrial advancement and pretrial release system. Next slide. So some of the things that are very, very important to us and that are aligned with our mission and our vision and our values at APPR and even CEPP as well is that when we look to partner with localities, there's certain things that should be in place and must be in place in order for it to be a good partnership, even from our perspective. First thing is that the locality has a collaborative team. This can look like your CJCC, that the locality must also have capable leadership that have a vision and looking forward to pretrial advancements, looking to be educated as well as trained. As Eleni mentioned several times, that there is an effort for community engagement, and this event today is really, in line with that there's a focus on racial equity, and then that there is a vision, mission, as well as values and goals that are called out and important and elevated as well. And so when we were reached out to from Dane County, for example, one of the things that they had interest in terms of support is really one of the reasons why, even again, as we're here tonight, is just to increase the collaboration amongst system stakeholders as well as community stakeholders. And so that led through several months of talking, led us to work together and partner on hosting this event today as well. So with that, we're going to yield the floor a little bit early and turn it back over to Colleen.
Great, thank you very much. Now we're going to turn to the local perspective, and I will introduce all of our 3 pretrial heroes at once. First, we have Carlo Esqueda. He kicked us off. He is the clerk of courts for Dane County since 2007. He has seen and witnessed and overseen pretrial supports for a number of years prior to the newly created Department of Pretrial Services. And he is also, I'm happy to announce, chair of our Community Justice Council in the last year and has been really impactful in that area. We also have Rhonda Frank Lauren, who is the inaugural director of that brand new department that I talked about, the Department of Pretrial Services. Rhonda is an attorney who has over 20 years of practical hands-on experience working with community and justice stakeholders. She came to Dane County from Crime and Justice Institute, where she managed a federally funded grant program implementing restrictive housing reforms. She previously was Wisconsin's first pretrial program manager, an assistant DA, a U.S. probation and pretrial services officer, and one of Dane County's first PSA, or pretrial assessment assessors, and an investigator. We're really pleased that she is the new Dane County Pretrial Services Director, and we're pleased to introduce her in this first very public way to the community. Last but not least is Judge Nicholas McNamara. Judge McNamara began his judicial career in 2009, right around this, little after Clerk of Courts Esqueda, about the same time I was here, practicing civil law as a trial attorney for 16 years. He graduated with his JD from the University of Wisconsin Law School in 1993, and he also is one of our key chairs for a key Community Justice Council committee, and that is the CJC Pretrial Subcommittee. So with that, I'd like to turn to our local perspective, and we'll start with Chair Esqueda and Rhonda Frank Lauren.
So thank you, Colleen. Very briefly, I'm going to just take a look back at where we have been with pretrial in Dane County. We've actually had a pretrial program since 1990, but we didn't call it that. I don't even know if that was a term of art that we were aware of back then in 1990. We called it bail monitoring. But the concept was the same. We had a team of social workers to whom defendants would be referred from our initial appearance court or by judges. And they would be subject to the kind of monitoring that Orlani described, just making sure that folks show up to court, to make sure that bail conditions were complied with, that there wouldn't be additional arrests during the pretrial period. But at that time, we had no concept of the notion of graduated risk assessments or dosages of supervision. At that time, for many years, up until really just recent years, everybody in the program had to meet with a worker once a week. Everybody in the program was subject to random drug testing. We have changed that now in light of what we've learned working with our various technical assistance partners over the years. Rhonda can speak more to what those changes look like now. But I have to say that we underwent a sea change with our partnership with the Arnold Foundation, now Arnold Ventures, beginning with the implementation of the PSA tool to assess risk and help inform bail decisions that are taking place at the circuit court commissioner and circuit court judge level. And with that quick retrospective, Rhonda can get to the good stuff.
Well, thank you, everybody. I've been the director for 2 months now, so I'm still getting used to these types of presentations. I came into the department at a really great place. It's a new department spun off from the clerk of courts. We're a quasi judicial agency, and it's a great space to be in. We work closely with our clients. We monitor them, ensuring that they're complying with their conditions of bail, and encouraging them to attend their court hearings. Some ways that we encourage them is, we provide them bus passes, we give them text messages, we do phone calls. Conditions of bail that are imposed by the judges or the court commissioners may include the GPS monitoring with exclusion zones, may include remote breath tests, and that sort of thing, and the random UAs. I think that a lot of people used to be put on some of these different testing tools, and we're moving away from it a little bit, trying to follow evidence-based practices. It's a great team. There are all social workers that are supervising folks. They're very good at communicating with their clients and identifying needs and referring them to the different community organizations. And it's not just like one time they refer them, sometimes you have to introduce the idea more than once. So, and the other role that the social workers have is to report to the court when people have violated bail conditions, but also when there's been some sort of change in circumstance, like they've been compliant and maybe they could be have a reduced level of supervision. So I think I sort of hit on all of the things that we do. I'll turn it over to Judge McNamara.
Okay, I'm Nick McNamara, a judge here in Dane County, Branch 5, criminal court judge for 13 and a half years now. We had sort of a planned agenda and time schedule, and all of the other panelists have zoomed right ahead of our schedule, which is great. Like leaders in a relay race, hopefully I'm not going to slow us down and get behind. But so normally when I talk about pretrial issues and the special challenges and decisions a judge has to make, I almost always start by telling the story of the very first bail decision I had to make, how I made that decision and how it turned out. But I've done that several times. Some of the people here probably attending even have heard it, and I'm not going to do that tonight. Actually, I want to do a little broader look, kind of give hopefully a wider context, some perspective on pretrial decisions, how they fit into a criminal case process more broadly than just a single example. So, starting again I realize this is a big picture, but every community and every core challenge for a truly representative government is to somehow efficiently structure peaceful order, safety without resorting to tyranny, while at the same time promoting and protecting freedom and liberty without falling into anarchy. And so while obviously not perfect, even obvious to those at the very beginning, especially insofar as women, Black citizens, Native Americans, and others were excluded, the creators of our country, the founders and our state, attempted to achieve the balance I'm talking about by recognizing individual rights as a shield or a limit on the overwhelming power of government. And although it comes up in a lot of different contexts, really a criminal prosecution is a clear, sharp point of intersection where the power of the state expressly encroaches on the inherent freedoms and liberties of an individual defendant. And as a community, we generally accept this as long as the government follows the rules established by the people, expressed through our constitutions and the rule of law generally. In a phrase, we usually call this demand for following due process, a phrase that's used in our laws, our constitutions, but it is a little ambiguous, perhaps intentionally ambiguous, perhaps not clear enough. It's sometimes helpful, I think, to actually concretely recognize so that we can protect and guard specific rights that are extended to everyone. And those are things like the right to be secure against unreasonable search and seizure, the right to remain silent, but also the right to be heard, the right to effective assistance of counsel, the right to confront our accusers, the right to a speedy trial, the right to a public trial. That's a huge thing that not everybody in the world gets. And the right to a trial by an impartial jury of our peers. And this is just a partial list of some of those rights. And we endorse and protect those rights, those inherent rights, so completely that we demand due process and fairness for people even who have been convicted of a crime, found guilty after a fair trial, or have admitted guilt by voluntarily entering a plea. We even demand that our government not inflict cruel and unusual punishments on those who have actually been convicted. Even those people have fundamental inherent rights that we recognize. And the role of the judge is special in these proceedings and the whole process. I recognize that I'm called upon to protect the safety of individuals and the community generally, but I'm not a prosecutor, I'm not a police officer. I'm charged with ensuring that due process and individual rights are followed. But I'm not a defense attorney or an advocate. I'm between these different conflicting interests or parties, maybe like a wall. We sometimes say like a gatekeeper. For me, conceptually, I prefer to think of myself as sort of a bridge facilitating the balance between what we really need and what we want. So when you understand how the rule of law and fairness and due process works, even all the way through the imports of convictions and sentences and consequences, hopefully everyone can recognize that these protections absolutely apply to individuals at the very beginning of a prosecution. And that people merely accused of a crime actually have more. It's because unlike a convicted person, the accused has the presumption of innocence. I worry sometimes that people hear the phrase presumption of innocence and think that it's intended to mean something sort of temporary, something sort of tentative. I try to emphasize always that the presumption of innocence is innocent, is innocence. It's the same thing. We, in fact, instruct juries at the beginnings of trials that criminal complaint or informations, we say nothing more than a written formal accusation charging the defendant of one or more criminal acts. You're not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. And we say multiple times during a trial that defendants are not required to prove their innocence. The law requires that they remain innocent until proven guilty beyond a reasonable doubt. I was talking about constitutional rights. Almost all of those familiar to everybody. Some people here tonight might be surprised that the phrase presumption of innocence, even the principle of innocent until proven guilty, is actually not in our constitutions. It's there certainly in the core essence of due process, and it's probably not there. I won't pretend to understand the minds of those drafters, but it's probably not there because the concept of presumption of innocence is older even than their basic, older than the concepts they introduced in the Bill of Rights. It was so firmly entrenched, they didn't have to include it because they all understood it was absolutely a fundamental part of justice. It's such a given that it's just not even expressed, which is perhaps surprising, but I think that's the reality. And so the judge's decision regarding bail and bond conditions begin with these very fundamental core concepts. We don't just sort of, exist in this philosophical world, though. There's obviously practical realities. I understand impacts of my decisions. And I do worry about the safety of individuals, alleged victims, witnesses, the community generally. But as our national presenters, Dr. Banks and Ms. Rojas were explaining before, it's without any doubt that there's a profound negative impact on individuals, families, sometimes businesses, communities generally, when people are detained while they're still innocent. People lose their jobs, their financial resources, they can lose housing, they lose connections with family and other natural supports. Their self-esteem, their stigma, their self-esteem is shot. They could go into a mental health crisis if they hadn't started already there. And in this way, pretrial detention, when they're innocent, it can actually have a negative impact, not just on their lives, but on the safety of the whole community. They're going to be released. One of the core values of even our punishment system for someone else, for someone who's been convicted, is that there can't be excessive penalties. And that means the people even convicted will be in our community. And certainly people who are innocent still should be in our community, except in extreme cases. We could cast a really wide net and make sure that anybody accused, let's say even of a violent crime, will not commit a new violent crime while they're being prosecuted. And that wide net would, because it would have to be wide, because we can't really accurately predict violence, which is actually rare statistically. We'd be catching a lot of people, netting a lot of people who aren't dangerous, who don't need to be held. And not only are they going to be damaging their lives, their families, economically and otherwise, but we're going to need bigger jails, bigger prisons, because we know pretrial does result in longer sentences. Research has shown us that. I'm not sure why. There's reasons, but it's just a truth. So we're going to need bigger prisons, and doing all with more guards and more staff, and doing all that means we're going to have fewer resources for educational opportunities, mental health treatment, addiction treatment, job training, all the positive community benefits that can actually reduce crime rather than make them worse. I mean, it's a double negative. As a judge, when I have to make a decision, it'd be the easiest thing in the world for me to just assume the worst about a person and the future choices they're going to make. I mean, that's the easiest job. In fact, you don't need discretion. I don't need to use judgment. I can easily assume the worst. But it's not accurate. It's obviously not fair. And when you realize doing that's going to make things worse for the individual, families, and the community broader, you've got to really do a gut check and say, why am I doing this? There is, besides the bail issues, and of course, there's this amendment that I want to turn to about amending our Constitution, there are other laws that affect what's going to happen here. We still will have both constitutional and statutory rights to a speedy trial. And if we're holding more people while they're innocent, pre-trial, because they can't afford the cash bill that we've set, or eventually if we're doing an excessive amount of just general pre-trial detention, the speedy trials are going to come forth, and we're going to need resources for that. We have to deal with that. We can do it, but it would be a huge burden on the system. So on this constitutional bail amendment, which almost certainly will pass, I mean, I'm not a forecaster for such things, but it's hard to imagine the way it's worded that anybody would ever vote no. And there's a certain honesty about it. I mean, a certain reality. The lawyers that are observing this, attending here, know that although we articulate risk of appearance, it may seem to them that we are still keeping an eye on risk of new crime or dangerousness, even if we used a different phrase. And so to the extent that taking into account a violent history or potential risk is perhaps more honest, that's maybe not altogether a negative thing. But if the people that really are some of the supporters there for this, I'm concerned that they want, when they say they want higher cash bail, what they're really saying is they want higher cash bail that prevents people from getting out, that they actually want judges to use cash bail as a mechanism to detain people. And that's not honest. That's a different system. I mean, one of the key sponsor of the bill, it started actually in 2017, and she's very, very clear about how she got this started. There was a man, she refers to him as a grandfather, who was accused of sexually assaulting his grandchildren. And she became, as others, she says in the community, became concerned, appalled is the word she puts on her website, that he was out on bail. He had posted $75,000 of bail. That is a huge amount of money. Obviously not an impoverished person, but she still couldn't understand why he was out. And that's what's led to this amendment to the Constitution. I don't know if double that, $150,000. If the argument is that whatever amount it is that lets him out, it's too low, well, that's a different system. That's just not what we do. I'm not sure why we would do that, but I'm concerned that that is the way some people are hoping that we'll implement it. But again, as I said, again, I think probably the defense lawyers that have an opportunity to hear this recognize that maybe just being honest about seeing that risk we should deal with. And I think some places where, well, in fact, I'm aware, I know for sure, some jurisdictions that have completely eliminated cash bail have implemented broader, more, let's say, loose rules and procedures that allow preventative detention. In fact, the federal courts allow that. Maybe some people think that would be honest and still hopefully maintain some of the principles I was talking about earlier. So hopefully it gives you some insight, at least into my thinking. I'm not speaking on behalf of my colleagues or the judiciary generally. These are things I think about when I approach these issues, and I'm glad people are interested enough to listen. I'll stop talking. We're still ahead of schedule, so.
Thank you. Thank you, Judge McNamara. And I think everything you bring up and everything we see in the paper leads us to the complexity of a one right answer on this issue. I know we have asked for this to be a conversation. So in that, I ask that folks, Lauren will guide me as far as the technology, but you can certainly put your questions in the chat. What we will do is, depending on the number of questions, I'll either popcorn or we'll go one at a time. I know our friend and colleague, Evelyn Cruz, had a question about pretrial services and where is it located and what does that look like? And I think I would also throw in there, and Evelyn can certainly be promoted if she has more questions, but for the local folks, where do you see pretrial services evolving to? Are there areas of innovation that you can see potentially on our future in 5 years, in 10 years, or tomorrow?
Can I answer that first? Well, first off, pretrial services, the actual location is in the courthouse on the 5th floor, if that's part of the question. Where do I see it going? We're hoping to partner more with community resources. This year, we're planning on collaborating with a couple different community organizations to have a peer mentoring for people who are referred to us by the courts, so they're on pretrial supervision, but we've identified that they have maybe some needs or would benefit from having help from, in a way, like an older brother type thing, helping them stay on the straight and narrow. And we're hoping that the peer mentorship could continue even after pretrial supervision is done, that we've made connections in the community for these folks. So that's one of the big changes that I see that is going to happen this year.
Great, thank you. And I see Evelyn has been promoted. Evelyn, if you have more questions, please go ahead and ask. Unmute yourself and ask. Thank you. Welcome.
Thank you. Actually, I was just that was my question, like where the services would lie, and I heard you say peers. So, and I know that is one of those services that, as community organizations that have supported jail diversion programs, that we are very interested in continuing to support. So I guess I'll just be listening for the time being. Thank you so much.
Thank you, Evelyn, for that question. And I guess that kind of, I'm wondering nationally for Dr. Banks and Arlene, what innovations have you seen in pretrial, and where does the community and community involvement intersect with pretrial services nationally?
So I'll start with innovation and throw it to my colleague Arlene to talk about the community involvement. What we're seeing in terms of innovation is really kind of what Rhonda was alluding to, two areas where we're seeing the evolution of pretrial supervision, transitioning from just managing failure, those that are in compliance or not compliance, to adding support of what we're calling broadly supportive services that are need-based services to address substance use, mental health, housing insecurity, other areas of need as well. So we're seeing this evolution where folks are, starting to understand, and in a lot of ways, it humanizes those that are, accused of offenses at that point in time as well, give them supports that they need that sometimes go beyond even the pretrial space by connecting them in a lot of ways with, existing CBOs, community-based organizations that are already, providing those services. And so one of the last positions that I created in Harris was a position that would monitor that and be a, referral specialist that focus specifically on connecting those that are in the pretrial space with the available community-based resources, again, to help them be able to move forward. We talk about, when we talked about equity and we showed that slide, those things that they may need may not be within the criminal legal system. It may just be something where they have some other things to help them actually get across the finish line as it relates to the criminal legal system by having some other things and other needs that they have being addressed. So that's what one we're seeing. And the other place is involving impacted people within a conversation in a very, very meaningful way. And so we're starting to do that from our organization standpoint, where we have folks on our trainings, we have them partnering with us within the jurisdictions that we're working as well. And so, both of those things that we talked about, involving impacted persons, as well as supportive services, are kind of, two things that are connected to even what Rhonda just shared in terms of what you guys see or plan to do locally as well. And with that, I'll throw it to my colleague, Orlene.
Thank you. Yes, I'll double down that applying a racial equity lens, like really looking at racial equity is one of the things that we've seen more and more localities and jurisdictions focused on. And that begins with looking at their data, disaggregating that information by race and ethnicity, looking at whether any one group is overrepresented or having a different or underrepresented sometimes, and having a different experience through the process. As well as numbers of them in jail, like actually being detained pre-trial in comparison to other groups. And what was mentioned, really this concept of ways in which we work with community more. So it's bringing community to the table as a partner, understanding that they have something valuable to contribute to the work that criminal justice practitioners want to do in these change areas or reform areas, and that we're bringing them, giving them an equal seat and voice at the table, with that level of engagement, but also that we're going into community when it comes to supervision, that it's not just having the person report to the office. And, a lot of the times those offices are within courthouses. It's establishing spaces in community that are closest to them, that allows to understand what resources there are, what supports there are. And in particular, as Colleen mentioned, the peer supports, it's a big one. It's one that's taken off, and that there's a lot of investment. It has a number of different names. In some spaces, they call them navigators. And so they're people that are there in courthouses or as part of pretrial programs to help the person connect to those supportive services that Dr. Vance just spoke about, and provide the perspective of they've been there, they know what the process is, and they can really provide like that insight, that wise guidance of like, these are the consequences if you go down this route, but also these are the rewards, or these are the positive outcomes that you can have if you follow these other instructions or steps.
I want to speak up kind of locally about some of the conditions. Wisconsin does have two unique, somewhat unique components for these pretrial issues. One is we don't have commercial bail bondsmen. Kentucky doesn't, but not too many other states who still have cash bail have eliminated commercial bail bondsmen. So the corporate profit motive that happens there does not happen here. Wisconsin, though, also has almost, I don't know if it's unique, but it's particular bail, we call it bail jumping charge. And it means a lot more than just not coming back to court. It means not following any of the conditions set by the court. And so, for instance, although it's legal to consume alcohol for a person who's on bond with a condition to not drink alcohol is possibly committing a new crime and possibly sometimes charged. So when we monitor that, that creates some issues. We do try to find out. So, locally, we have court commissioners who make the initial bond condition and bail condition, bail amount decisions, and I get asked to review that. People are allowed to ask for a review every 72 hours. That doesn't really happen practically, but they can ask certainly more than once and multiple times. But it happens a couple of times a month, or it happened just last week. A person seemed to be struggling with complying with the bond conditions about some remote testing. We are having another hearing. I did intentionally put on the record what's going on and found out a lot more about this person's life. And then we kind of started talking with the prosecutor and defense attorney. Why is this condition there? And it turned out that maybe it was a condition to begin with that should never have been there. And I'd like us to do a better job of, as Carlo Esqueda mentioned, dosage and appropriateness. We have the great team of social workers and leadership at the pretrial services, so we need to be smarter, hopefully, about using them. And then finally, just it's perfect when someone wants to do all of these things voluntarily to demonstrate change, commitment, to help them make improvements in their life. It is a little more complicated when we're judicially demanding compliance with the possible consequences of even new criminal charges if it's not followed. And I worry about that.
Thank you, Judge. I will say for everybody online, we may have miscommunicated, but please go ahead and put your questions in the text, or in the chat, and then we'll be able to answer them. We do have a question from Jessica Williams. I'm I'm hearing talk about meeting the needs of people on pretrial detention and referring them to community-based organizations. What is the plan to fund community-based organizations that are already underfunded? I think that's a great question. And I was curious myself, Dr. Banks, when you mentioned the last thing you did was create a position that was that referral source. Were the community-based organizations, was that like static funding? Was there funding per person? Or can you talk to us about it and help us out here?
Yeah, that's a great question. Let me give a little bit of context to that as well, if I could. And it may not be, it'd be more of just shifting resources. Judge McNamara kind of alluded to it earlier that each locality has finite resources. And so it's a matter of trying to use the resource that you have available in the best way. Nationally and historically within the United States, and what I would call a national tragedy in a lot of ways, is that we have, from a mental health standpoint, we institutionalize our citizens at an alarming rate historically. We realized we were doing something wrong, and then we deinstitutionalized them without necessarily building what we call an infrastructure to support that. And with that, and to that end, what that has resulted in is that folks that are having mental health issues, for example, in the LA County, which is the largest county in terms of population in the United States, the LA County Jail is also the largest mental health facility in the United States as well. Concurrently, Harris County, where I came from, third largest population in the United States, the Harris County Jail is also the third largest mental health facility in the United States. So it's a matter of maybe not necessarily finding new funding, but shifting existing funding to more in the pre-entry space before folks are incarcerated or detained for various reasons. So what we did locally when we created that position, it just made it a priority in elevating it. And it came out of we had first line staff who were doing these things on their own out of the kindness of their heart, trying to see what they can do to support people. And we realized that we need to standardize that across the board and put the money behind that. So it was a matter of just prioritizing that, seeing that there was certainly value in a lot of ways, humanizing people as it relates to their needs as well. Even though we did not fund CBOs in that effort, we were looking to give space to them in our operations to kind of make sure that we had what we call a warm handoff from that referral to them getting to the CBO as well. But there, again, there's potential, opportunities for partnerships with CPOs as well that you guys can, certainly explore in terms of how you can partner with them, and maybe, may not be direct funding, but just housing space and giving space for them where you can, bridge that gap in terms of the warm handout from where the person has a need and them getting, access to that service and providing space for them in a way that maybe can reduce some costs for them in some other ways as well. So I would say just, by way of suggestion, just exploring the possibilities and seeing what it looks like. I'm just doing something, even this, incremental has a, huge impact on people needs being addressed and them potentially succeeding during the pretrial stage.
Great, thank you. I do have one previous question, and then we will take Mr. Kriegel's question and then Ms. Cruz. And the question really is about those communities who have, seen, witnessed crime. Is there a way locally and nationally we can communicate around what pretrial and bail is in a better way? In a way that folks can understand? Judge McNamara certainly gave us a good background on the issue and the complexity about it, but it does seem to be the headlines. I'm wondering if folks have some takeaways for our residents on the phone to when you see those headlines, and crime touches everybody in our country, unfortunately. Is there a way to contextualize bail and pretrial? And then if we can possibly promote Mr. Kriegel and then Ms.
I mean, I'll say that, yeah, communication is key, but part of that is education. And from our perspective, when we're talking about getting people to know and understand and contextualize the headlines that they see with what is actually happening nationwide, but also just locally in their communities and with the system, is we need people in our position, both those who provide this assistance or support nationally, but also those at the county level that are tasked or charged with administering and running the systems, to give information to the community, because a lot of times the only information communities are getting are from the headlines, are from the local newspapers, and they don't know if there's a website for a program, if there's a website for the county that really talks about their pretrial system, that offers them information. Some counties and some pretrial programs are now making dashboards publicly available where they're providing data on arrest, on compliance, on returns to court, like appearances, connection to services, the type of charges that people are coming into their programs with, to really be more transparent and give community another source, another source for information. I think that events like this happening more often or being more open and available to the community at large can go a long ways in helping with that and providing just another side of facts and information for people to really have everything that they need and make informed decisions about what they're reading.
And just quickly, I'll add to that just to say, to tell the success stories. They're based on the data, you heard from us, there are 80% of people that are succeeding pretrial. And admittedly, we have not done a great job nationally with telling those stories of the 80%. You do hear the 20% that do fail, and that is hyperbolic, and it does tend to impact the perceptions in a very skewed way. Again, not minimizing anyone that's a victim or anyone that does not comply during their pretrial stage, but we just need to do a better job of telling the success stories and making sure folks are aware of all those people that are succeeding pretrial. And then, as Lenny said, just sharing that data, because again, that goes a long ways, and without overcorrecting, for everyone based on a few that are not successful during the pretrial stage.
Great, thank you. And I will give an update, one real quick update from Dane County CJC. We are in the midst of updating our dashboards, which will include pretrial. The pretrial services department also does have brochures that everyone who's registered will also get in their email back. Judge McNamara, and then we'll go to Mr. Kriegel.
Thank you. So the complexity of that question about educating people, even promoting success stories, is more complicated because of just human nature. I might be stepping into Dr. Banks' space a little bit here, but humans are horribly susceptible to what psychologists call hindsight bias. That after something happens, it's clear to everyone that of course that's what's going to happen. Clearly, and any Packer fans know what this means. It's Monday morning quarterbacking. It's like, should they have gone for the touchdown or kicked the field goal? Of course, it was clear after it happened, but we didn't know. And those are my decisions. I don't know. I make the best decision I can on the information available. Things don't always turn out the way I expected. And actually, I try to emphasize to defendants, even they can honestly say, I am never going to be back in front of you. This will never happen again. Thanks, Judge, but have a good life. I'll never see you. And I see them again. And they're like, yeah, well, I was wrong. I mean, not just the judge was wrong, the defendant was wrong. I mean, for lots of complicated reasons, perhaps. But hindsight bias is real. And it's broad that way. I don't know if Dr. Banks can fill us in more professionally.
Does I think you hit it right on the head, in a lot of ways, Monday morning, quarterbacking in a lot of ways, obviously is, certainly true. And then just only thing I'll say is that from a human behavior standpoint, for every negative thing that's done to a person or that we hear, there needs to be at least 3 to 12 positive things to offset one negative thing. So you think about the cadence and what that looks like in terms of just, how things are shared. And so it's, it's important to just be conscious of those things as well. And just being conscious of those from a human behavior standpoint.
Thank you. Thank you. And maybe in the future, we can share some success stories along with that successful data. Okay. Do we have Mr. Kriegel? If you can ask your question.
Okay, thank you. Can you hear me?
Yes, we can.
Yeah, about 6 years ago, the National Association of Counties did a nationwide study that showed that about 2/3 of inmates in county jails across the country were either pre-trial, pre-arraignment, et cetera, identified that as a serious problem. And one of the contributors to that serious problem is that many people cannot afford attorneys, et cetera. And of course, the Wisconsin budget is very stingy when it comes to public defenders. Not enough public defenders, and they're overworked and so forth. And of course, counties to some degree can resort to bring private attorneys to fill that role somewhat. Dane County is not a poor county. Frankly, I think it'd be cheaper for Dane County to budget some money to hire more attorneys for this purpose than to keep more people in jail. Actually, I think I can show that it would be less expensive to do that.
Do you have a question, Mr. Kriegel?
Yeah, the question is, why doesn't Dane County take that approach to address the buildup of pretrial, pre-arraignment inmates?
Clerk Escada, you know the budget issues better. We do have a program we're required by law to be able to give effective counsel to people who may be relatively indigent but still not qualify for a public defender. And we do that, and we call it the Criminal Defense Project. It's run through the Clerk of Court's office. There is a statewide shortage of not just public defenders within the public defender entity, but of private lawyers willing to do this. And it was exacerbated by the COVID crisis. And Mr. Kriegel raises a huge question. It's bigger than Dane County, but we try to help it. But Carlo?
Well, one of the issues that we notice here, well, first of all, I should say that compared to other jurisdictions I visited, there are way more people being released pretrial on recognizance bonds or signature bonds than in other places. We're doing a really good job on that. Nevertheless, we do still see that there's a significant number of pretrial folks being held in the jail, but they're being held there for reasons other than cash bail that they can't pay. They're there because of warrants or holds from other jurisdictions, or perhaps they're there on a Department of Corrections, alleged parole violation. It has to work its way through the system. The number of people that are truly in our jails pretrial who are being held solely for the reason that they can't afford whatever cash bail was set is pretty small. I don't have the number right now. That number is very fluid. In fact, this week at a meeting we're going to have, we'll learn a new number. But to the extent that we can address some of those issues, we're trying to do that. System partners getting together to identify perhaps changes in policies in those other agencies that will allow for at least faster processing of these holds, if not resulting in immediate release for these individuals.
Thank you. And I see we have Evelyn Cruz. I think you had a follow-up. If you can ask your question quickly, and then we will move on to folks with other questions. Thanks, Evelyn.
Thank you. Yes, I really commend the equity lens. As someone that is part of a community organization that serves the immigrant community is really important. And I also appreciated the question about the funding in ensuring that CBOs have funding to provide those supportive services and navigation. But it's more of a comment that it's not, it would not be a substitute to ensuring that Title VI requirements of other organizations that have more robust services for immigrant communities are there and available. So the Title VI requirements for language access aren't always available. So in community-based organizations aren't always able to meet those needs. Thank you.
Thank you. I see Clark Rogers had a comment. I think we have to stress that people on pretrial are innocent until proven guilty. They are not on probation or post-conviction supervision. I'm not sure if we have Eric Holland, if he wants to be promoted, but his question is, the number of people in jail with pretrial detention without holds is higher now than it was before the pandemic, often by more than 100 beds. This group was growing steadily until recently. Do you think pretrial detention will be able to at least return to pre-pandemic levels? And I see Eric has been promoted. I'll see if he has any clarifications before. And let's pull it out and then in. Right, nationally, what are we seeing in pretrial detention? Have you all noticed any changes nationally in the pandemic, and then locally? So I'll start nationally, and Eric, if you have follow-up or clarification rather, you can ask that after they.
Yeah, I would say that we did see a trend to less people being detained nationally pre-trial during the pandemic because of COVID and just how serious the transmission of the disease was, or the virus, and obviously all the impacts and how it was overwhelming other systems such as the healthcare system and just causing so much death. Part of that had to do with counties changing policies and practices around arrest, around who was brought into court versus who received the summons. So there was a shift in that. And that's one of the things, obviously, we work at the national level at the law enforcement end in terms of as a way to address pretrial detention too. Does everyone need an online arrest, or the people that can just get summonses and, they'll come back to court and go through the process that way? And what we were seeing towards the middle of 2022 was that in some places, like the status quo was holding, but the latter half of 2022 and into this year, that's when we began seeing like those policies and practices that were implemented during COVID being pulled back. And that's where we're seeing a resurgence in the numbers for pretrial detention.
Thank you. Any local folks want to respond to that?
Actually, while Orlando was responding, I pulled up the Sheriff's Department inmate roster to get some numbers. I know Eric has them because he does an excellent job of keeping track of it. And I haven't been able to sort it out right now. Pre-pandemic, the data I was tracking, and Eric and I have consulted about this together, was around 25%, just pretrial without holds. And I'm sure it is higher. I know it went up. And it should go back because, I mean, the trial crunch post pandemic, we're mostly through in the courts. Cases are moving. The DA's office is thoughtfully dismissing cases for people who have not reoffended in years and don't pose a risk. And other cases are resolving with various, time served. And some people are, we're still doing trials for cases that go back to 2020, even 2019. But I sure hope they can, Eric, go back to before.
Thank you. I see another question from, this one's from Supervisor Wegleitner. Does Dane County have cash bail numbers broken down by race? If so, is it publicly online? I'll speak a little to that from the CJC's perspective. This is clearly an area that we've been working on steadily, actually tried to get it down to the lowest common denominator. For instance, a misdemeanor with no holds, no enhancements, black versus white, What are the differences? It's more complicated. And our CJC research team is actively working on it. We've also worked with Judge McNamara and Chair Esqueda on this as well. So it's not here yet, but we continue to work on the issue. Let's see.
I'm sorry,
yes,
out of order, but so Eric, I just did a quick calculation on the current CO pretrial only, so not with a probation hold or a hold. And there's 181 inmates with court pretrial only, and that's actually 22% of our jail population. The jail population's high, 817, higher than I've been aware of lately, but only 181 of them are pretrial only, 22%. I'm not saying that's a good number and just raw numbers. I think that is probably higher than it was before. Percentage, not so much. Not all good news. I'm not bragging about that. And Eric, you know, I should talk offline about what else you've been seeing. So I'm sorry to go back to that, but since I had that calculation.
That's okay. I am going to, we've had Mr. Kriegel ask a question, so I see another question in a separate spot from Carrie Fanning. And this is to everybody from a national to a local perspective. From a data perspective, how are potential biases, example, race, gender, etc., being addressed in the pretrial process, ranging from arrest, diversion, assessment, through pretrial decision-making, decisions to detain or release, and case disposition, so the entirety of the pretrial process. So how have you seen nationally, and let's talk a little bit about what we're doing locally on our research as far as bias in practice. So let's start nationally, and then I'll go to you, Director Frank Lauren.
I mean, the question begins from a data perspective. So a lot of what we're doing nationally is encouraging people to begin or start with data. And so that even begins with the basic of, are people collecting race and ethnicity data? How are they collecting it? Is it self-reported? Is it observational, either by a program or department staff like pretrial, or by law enforcement when it is available? You know, best practice is for people to be able to self-report their race or ethnicity and then we're talking about, well, if our different agencies that collect data, like the jail and the police, collecting it differently? Are they using the same terms for your community? Does your community have a particular population? Like, do you have a high percentage in terms of, you have a reservation Native American community? And so it would be important for that to be reflected in the race and ethnicity. I know that in Wisconsin, there's a Hmong community. And so it'd be important for you to track in particular how Pacific Islander and Asian communities are tracked. And then if you don't, then we work to provide support and assistance in creating a data collection protocol for race and ethnicity and implementing that. And sometimes, you know, a lot of what people miss in the implementation is, so you have to train this then, because if you're saying that we're now going to collect self-identified information, where staff now is going to have to ask this of people, and sometimes like there's a lot of reticence around asking about race and ethnicity from staff, and so your data ends up not being what you want it to be. So training is an important part of the guidance there. And then once you do have it, to conduct analysis, to look at different decision points. I see that you're talking about the pretrial process, arrests, diversion, assessment, all of those different decision points, looking at data desegregated by race and looking at charges within that data and anything pertinent. So for example, if you're talking about arrest data and you're talking about charges, and you have identified a particular community that's overrepresented in a particular charge, the next level that you might want to identify is neighborhoods. Are they concentrated in one particular neighborhood? Because then you would want to include that and bring them on and be part of whatever strategies or solutions you're putting in place to address that disparity.
Great, thank you. And I know Director Frank Lauren and I were chomping at the bit on that question because as well as Judge McNamara and Carlo, Clerk of Courts and Chair Escada well know, Dane County is one of the very few counties in the country who has been in partnership with Harvard's Access to Justice Lab for the last 5.5 years, doing just that, studying the PSA and looking specifically to see if that assessment leads to more disparity. We know our system is disparate, but what we're also looking for is this assessment tool adding more to the disparity that currently exists. The only other thing I'll mention about that is the other unique thing about Dane County Criminal Justice Council is we do have data sharing between those agencies, between arrest, between pretrial, between the DA's office, the courts and clerk of courts, and the sheriff's office, and that is part of the CJC's work, right? We have a very talented research and innovation team that works with the data and trying to just figure out how to connect the dots between all of those very siloed agencies. And then I do see, maybe we have time, make this the last question, and then I'll give folks an opportunity just to give a few minutes of, if you have any closing thoughts that you want to leave the community with. So how common is the use of screening tools like the Hawaiian proxy in a law enforcement context? I was just in a county where the law enforcement officers did have to put basically a proxy on the back of their booking sheet. So nationally, what are you seeing as for law enforcement or police agencies and the use of any sort of assessment in the field?
Yeah, we're not. I'm, you know, Eleni may know, but I'm not. We're not aware of what that looks like from a volume standpoint. You know, again, we're looking, you know, to kind of further engage law enforcement. You know, to Carrie's point, she talked about just various decision points, and one of the things we want to just elevate in the conversation is just that what we're seeing nationally is just encouraging localities to have the courage to have these conversations and to look at that data and to not, you know, and not be scared to address the pink elephant in the room or in the community as well is a huge, huge thing. And so we've seen some communities that are, you know, Eleni does a presentation where she talks about the thick and the thin involvement or engagement. We see some communities that are just not willing to have the conversation, and we see some communities that are engaging folks and having reports done like A2J is doing for you guys to begin elevating and identifying those things so you can have those very tough conversations that hopefully lead to policy changes, you know, down the road as well. So Arlene, I'll throw it to you, see if you're aware of anything related to the Hawaiian proxy specifically.
Not the Hawaiian proxy specifically, but it is common. I worked, for example, in Charleston, and they were using a proxy tool. Other areas are actually use a PSA at a much earlier level. And so it is common. I think one of the issues that you run into is how staff gets trained in using it and whether they are making decisions based on it and adhering to the tool, and whether or not they have the tool, but they still get discretion to deviate from what the tool is telling them to do.
Great, thank you. And now I am going to close it off, and the PSA is public safety assessment. I'm going to close it off, and everybody give, if you can, 10 to 30 second key takeaway that you want or you hope that our community hears. Chair Escada, you welcomed us, so I'm gonna put you on the spot and then we'll go in the same order that the agenda was. So Chair Escada.
Well, one additional piece of information I wanted to give with regard to the peer navigator issue and how it's funded is the county board was generous enough to apply to the pretrial services budget $20,000 to sort of pilot that process. So that'll be enough for us to get our feet wet with it, figure out how it works, establish some track record of success, and then hopefully expand it and provide funding to the agencies that are going to be partnering with us. And the other big takeaway is just looking back at the culture change that we have undergone in pretrial over the last couple of decades, and especially as concentrated as that's been in the last 6 or so years, I think we stand on the brink of yet another culture change. We talked about dosage. We talked about the overuse of some of the supervision tools like electronic monitoring or breath testing. I've been to jurisdictions larger than ours where they have very few people out on bracelets, and the system is still working and it's still preserving people's liberty interests pre-trial. And so I see us moving gradually but inexorably towards that kind of an outcome.
Thank you. Dr. Banks and then Arlene.
I'll just say in terms of a quote from the late Dr. Martin Luther King Jr., which simply says that when you can't, fly, then run. If you can't run, then walk. If you can't walk, then crawl. By all means, continue to move forward. And so we just encourage you, every little bit that you do is important. We talk a lot about data, but we want to also elevate that is a person and a family and an individual behind that data as well. So keeping the human element in what you're doing and keep doing something, moving it forward.
Thank you, Arlene.
And I'll say that at the national level, we're not focused on what people might think at the community level of catch and release and just letting everyone go or being against people that pose a threat or risk a community to just be out and not be detained. What we're really focused on is ensuring that folks that can be safely in the community pre-trial, either again through recognizance, through supportive services, pre-trial supervision, or other conditions of release, that those are the folks that happens for, so that then we can focus the resources, are very, as Judge McNamara mentioned, finite, limited resources on the folks that need that level of oversight, attention, and then we can also conserve some of the extra resources that we might be spending on people that don't need to spend and funnel it back to community as a way to support people and identify issues and make sure that, people don't keep coming through the door into the system.
Thank you. Director Frank Laurent.
Well, we're going to continue to look at what evidence-based advice is out there. We're trying to keep abreast of what the research is showing. We are going through the sea change of changing our language that we use in our office, and we're doing a people first language. These are our community members, and whatever happens during the pretrial stage or thereafter, the majority of these folks are going to be back out in our community. We need to not other them, and we need to figure out ways to lift them up and provide them the resources they need so that they can be contributing members of society.
And Judge, we've got just a couple of seconds left, so you get to close us off.
With this, I want to emphasize that with help like people here nationally, Dr. Banks, Ms. Orlani, we can do better. We have to do better, not just communicating to the public about how these decisions have to make and the complexities of it, but we need to do better. Families at a parade deserve to be safe. Families in their homes deserve to have them not broken into, and they have a right to demand that we do better. And that's what we're trying to do. And if we can't do better, they're going to look to other solutions. We have to communicate this, but we need to help them, all of them, and not, I mean, and including communities that are inundated by violence or other problems that are often impoverished communities. We need to help them too, everybody. So I appreciate the help locally and nationally that we're getting to try to do better. And I would, we may be just crawling, but let's move forward, as Dr. Blake said.
Great, thank you all. We will have this is recorded. It will be, you'll have links to bios, information. As always, thank you, Dane County community, for tuning in. Thank you, APPR, for joining us, and our local leaders for helping lean in and support innovative change and more racial equity in Dane County. So have a great night. Thanks.